Back to a health note. This will be presented in our popular segment called Focus on Health Law. This will be illustrated here by our well-known healthcare attorney by the name of Kenneth Haber, who is from Boyd's, Maryland. Mr. Kenneth Haber is an internationally acclaimed attorney. The moderator on this set is attorney Ramesh Khurana from the Khurana Law Firm located in Gaithersburg, Maryland. This morning, attorney Khurana has questions for attorney Haber. Let's join them.
My name is Ramesh Khurana. I am an attorney at law and I have my office in Gaithersburg, Maryland. I do primarily immigration practice, and today I am really privileged to have Kenneth Haber, who is a very seasoned and distinguished attorney in having his office in Boyd's, Maryland, but his practice is nationwide. And he is the former assistant U.S. attorney and the former senior attorney in the Office of Inspector General. We are glad that he has come to our studios to answer our questions in regard to False Claims Act cases. In fact, in one of the sessions, we covered False Claims Act cases, which was basically part 1. And Ken, don't mind, I'll be asking you some basic question again, so that sometime audience is different, so that we have the same start level.
Yes, sir.
So that for the purpose of better perception of the audience. So welcome to our studios.
Thank you.
Can you please explain to us what are the False Claims Act cases? Let's start with the definition, then we will move on.
Certainly.
Yeah.
Certainly. False Claims Act case is where somebody has identified fraud against the government, and it could be in healthcare, it could be in Department of Defense contracting or any other government agency contracting, and they've identified this fraud against the government and they want to do something about it. And by finding an attorney who handles False Claims Act matters, they can file a complaint against these people on behalf of the government. It goes under seal, and they then are called a relator because they're relating the case to the government. Their notice goes to the Department of Justice and to the U.S. Attorney's Office where it's filed, and it's put under seal. And then the government decides whether they want to get involved, and that's called intervening. And if the government wants to get involved, then they run the case. If they don't want to get involved, then the relator has the opportunity to withdraw the case, dismiss it, or to keep on going.
So, Ken, you say that when an individual observes that some kind of fraud has been committed against the government, is it a federal government or it could be state government?
Well, the False Claims Act that we're talking about is federal,
Federal claim.
and it'll be in federal court.
Okay.
Some states will have similar statutes for their own protection, but in this one we're talking about the Federal False Claims Act.
Okay. Now, what if somebody has committed a fraud by presenting fraudulent documents to the Department of Homeland Security, and that individual has obtained some immigration benefit? So, I don't know whether this kind of fraud can be reported to the government, or you are just limiting that kind of fraud in regard to the procurement of some material for the government.
Well, it certainly can be reported to the government, but it wouldn't be reported by means of the False Claims Act unless they are paying out, the government's paying out some money to somebody because of this false information being provided because of this fraud.
Okay. So that means where some kind of pecuniary or monetary loss is
To the
seen,
government.
only then.
Yes.
That case is covered under the False Claim Act. And another comment which you made in your opening remark was that government gets involved and it is the government's discretion to decide whether they really like to get involved. So who acts on behalf of the government?
Department of Justice will make that decision. They and the local U.S. Attorney's Office will decide who will be the lead in that in terms of prosecution if they're going to get involved. And quite often it's the Maine Department of Justice, but sometimes the U.S. Attorney's Office might say, well, we'll take this one, you know, you don't have the manpower for it right now, we'll do it.
Okay. And who's the relator in the context of this type of fraud to the government?
The person who comes to the attorney and says, I see fraud going on against the government's paying out money because of this fraud, there's claims against the government because of this fraud, and I'd like to get some money out of it, I want to report it to the government, and he hires the attorney to process the case. That means put it together, make it into a claim that's filed in court, and put together a memorandum setting forth the evidence that they have to support it. Because if there's no evidence to support it, unless the government could readily get evidence to support it, they're not going to proceed with it. So you'd want to put together all the evidence that you can in order to support it, and that's part of the relator's responsibility to have that evidence and provide it to the attorney so he can file that both with the Department of Justice and the U.S. Attorney's Office once he files the case itself.
Now, Ken, that gives rise to another question. Like you said, that the relator has to contact an attorney for the purpose, and attorney is going to collect some evidence and make a memorandum, or he is to file a complaint with the U.S. District Court. The question is it necessary that the relator has to go to the attorney, or can he just get in touch with the Department of Justice and start the case?
He would have to file it in court, the relator.
Oh,
And
it is.
it's a
No, it's
complica-
not like picking up the phone and talking to Department of Justice.
No,
or writing a small letter.
No, they would say thank you very much and maybe send out an FBI agent or Inspector General's office agent to investigate, but that doesn't get him the False Claims Act. That just gets him an attaboy and thank you very much. And that's fine. You know, a lot of people would prefer that and not get too involved, especially if they don't have a lot of evidence. But if they want to get involved, they have a lot of evidence and they want to get some money out of it, then they have to file the complaint, which means there has to be a complaint put together and filed in court. And that generally takes an attorney because most non-attorneys are not going to know the process to put it together.
Okay. So, how the attorneys who are retained by the relators, they are going to be paid for their time and efforts?
Well, that's between them and the relator. It can often be a contingency. There's also provisions for attorney fees in the False Claims Act, and so all that could be part of the pie that the relator and the attorney get that they can divide up.
Is there any cap on the attorney's fees? Like when you are making an agreement with the relator, can you say that attorney will charge 40% and the relator will be having 60%?
It depends on what the attorney's bar will
Permit.
You know, the relator's not doing any work, presumably, at this point in time, except providing the attorney information. It's not like he made a loss that somebody took money from him. No, they took it from the government. So consequently, it's not like somebody who, you know, got run over and then the attorney is charging him an outrageous portion, you know, that's supposed to make him whole. You know, here it's the government that was suffered the loss, and so consequently, probably a higher percentage than normally would be charged to an individual could be charged to a relator. You just want to make it reasonable under the circumstances, because the fact the relator hasn't suffered anything except that they may feel exposed to retaliation, concerned about that. So it's not a totally...
That may be a potential threat of any kind of damages.
Yeah, there could be that they need to be concerned about, but they really don't, because most people do not retaliate against relators. The case at first goes under seal, so no one even knows the relator filed it. And
Where the case is filed?
in U.S. District Court,
U.S. District Court. So it is filed under seal.
filed under seal.
Okay. The memorandum which you prepare, giving whatever evidence is available to convince the government that it's a good case for them to accept. So that is also kept under seal?
That's not filed. That's just sent to the U.S.
Department of
Attorney's Office
Justice.
and Department of Justice, that plus
Okay.
the evidence that they have.
Okay. So what do you include in the complaint, which is filed with the U.S. District Court?
Well, like any sort of fraud complaint, you'd set out what the people did and, what makes it fraud, what.
All those elements you'll
all
be
those
talking.
elements that you'd normally put
Okay.
into a fraud complaint. And, you identify who the potential targets are and you name them as defendants. And, you file that, like I said, under seal, and then you give the government the evidence that you have, all the evidence that you have that support that. And if the government decides to get involved, then they will take over the management of the case. And
So the relator's attorney is out at that point of time.
not really out. He will be counseled. The government will want to speak to the relator, interview the relator, and that will go through the attorney.
Right.
And the attorney, if he's experienced, can give insight to the
Sure.
government attorneys as well.
Yeah, especially
if
an
he's
attorney like you. Yeah.
Thank you.
Yeah.
But especially if he's debriefed the relator a lot so that he knows what the case is about and, not everything, that's put into a memorandum necessarily can give the exact details and insight that may exist in the attorney's mind. You try to put it all down, but it's not necessarily easy to capture all the little elements of the fraud on paper. You do the best you can, but then
Right.
in discussing it with the department attorney, you sometimes see things yourself that you hadn't seen before, and same thing with the department attorney. So there develops a communication there back and forth, and you're the individual who connects up the relator to the government. Although if you're smart, you'll make sure that the government feels free to ask the relator, any questions once you've developed the relationship, once they've decided to intervene. Then, if you got something quick you need to ask them, feel free, I mean, like you want them to feel that the relator is not hiding anything, doesn't have anything to hide, and is most cooperative.
Now, Ken, when you have prepared a memorandum and submitted it to the Department of Justice, basically justifying that this is a good case and deserves the merited attention for its acceptance, how much time the Department of Justice can take to make a decision on that?
Well, by law, they're supposed to do it within 2 months to decide whether to intervene, but when you're coming upon the 2 months, they will no doubt be asking for extensions. Your concurrence and extensions, it's under seal, so the other side doesn't even know it exists, so they
Right.
ask you if.
So, you are not objecting to it, so
No,
there
you're
is no
not.
objection.
There's no objection,
And
and the
court
court-
would usually grant it
Court
in
will
the
normally
interest of
grant-
justice,
in
right?
the interest of justice, and the fact that the
Right.
court doesn't want to possibly permit criminals to
Right.
get away with their crimes.
Right, exactly. Now, explain what happens when the FCA complaint is filed. What are the different stages following the filing of the complaint?
Well, you send off your package of information to the Department of Justice, and they will connect up with you, and you'd explain it verbally, just like you'd do any case, and they'll have questions. They'll have read your memorandum and everything. They'll have seen the evidence, and they'll probably have questions, that might seem obvious to you because you've talked to the relator already.
Right. You are
But
aware about the facts of the case.
You're aware, and they're just reading from paper, and so you answer those. You make arrangements for them to interview the relator, because he is as much. There's two critical actors there, other than the department, and that is the attorney and the relator, and they
Right.
want to make sure both are going to be on a playing field where they're going to be cooperating maximum with them. They want to make sure that the relator is clean as can be. that doesn't mean that they won't take a dirty relator, depending on the nature of the case, but quite often that could be, something that will make them decide not to get involved if the relator seems that he was dirty. And the attorney, if the attorney is not cooperative, if the attorney doesn't know how to follow the expected practices, that cause disaster. You want them to know that you're part of their team and that you're going to cooperate as much as possible, that they're not going to have any headaches from you, just like any other enterprise that you're going to be entering into whoever is going to be your partner in it. You want to make sure that they're going to be a full team player, and that's what they're going to be interested in knowing.
Great. Cameraman is indicating our time is up. Thank you very much for coming to our studios
Thank you.
and answering some of the very complex questions.
My pleasure.
Thank you.